I'm John McKee, Interim Associate Vice President of Philanthropy at UMB, and I direct the UMB Office of Plan Giving. I am pleased to introduce our next speaker, Aisha Snead. Aisha serves as the Community Outreach Project Coordinator for the Advanced Planning Program at the Maryland Volunteer Lawyer Service. She brings her skills to amplify the necessity of advanced planning for underserved communities by demystifying and making accessible the process of estate planning. These proactive and preventative measures increase better outcomes for individuals, families, and the whole community by decreasing the loss of legacies, community blight, and creating housing stabilization for generations to come. Aisha's presentation today is titled Planning and Controlling Your Assets. Thank you, Aisha. Please take it away.
So though I am talking about the importance of wills and avoiding probates, my presentation is normally called Protecting Your Legacy and Why Estate Planning Matters. First, I would like to just do, again, introductions of myself and MVLS. My name is Aisha Snead. I'm the project coordinator for the Advanced Planning Program with Maryland Volunteer Lawyer Service. We are a pro bono legal service. We've existed 40 years in the state of Maryland with a concentration in Baltimore City and the surrounding Baltimore County areas. We do service the whole state, with an exception for a few counties, though we will also work in those counties. Many of them have their own civil legal services. If they cannot handle the case or workload, they often defer to us. The goal of MVLS is to remove barriers to justice and civil legal matters, helping underserved and underrepresented people, marginalized, divested communities. We match clients with volunteer attorneys. We are the largest in the state with actually a small staff of about 30, but we pull from a pool of about 2,000 volunteers. We specialize in cases, what we call the 6 buckets, and family, housing, consumer finance, tax controversies with a low-income tax clinic, criminal record relief, which is the only time civil legal matters and criminal matters intersect here, and that is mostly workforce development and expungements and vacatures. And then there is my program, Estate Planning and Administration. So who are our volunteers? Well, they come from large and small firms, government offices, and corporate services. Most lawyers pledge to offer 50 hours of pro bono legal services a year, although it's not mandatory. So from those who commit to 50 hours a year, we pool and recruit volunteers. We offer trainings in new areas of civil law, and so it becomes attractive for our volunteers. People involved in civil legal disputes are 6.5 times more likely to be successful in their case if they have representation. We offer full representation pro bono, but 80% of low-income Marylanders involved in civil legal matters represent themselves. We do have income eligibility guidelines with your household must not exceed 50% of the Maryland median income. And right now, though this slide says June 30th, 22, we are waiting on adjustments for 2023. but it is right now about 33.5, which for a single person, with each additional person in your household, you can add 10,000. Now on to estate planning and administration. We like to separate it into two pillars. Consider protecting yourself, your person, and then your property, your assets, your financial assets combined. Estate planning includes, for us, wills, financial power of attorney, advanced medical directives, and then there are other additional documents to assist with avoiding probate, such as beneficiary designations and life estate deeds. As a definition, estate planning is preparation of your documents that will protect your health care and your assets. These documents will give you the power to make decisions and choices about what you want to happen with your health care while you are living, your assets, your property, and also your assets and property when you are deceased. Why does estate planning matter? And why is it crucial for everyone? It promotes peace of mind and family unity. We know that death can bring all kinds of emotions and grief and cause family disunity as we begin to fight over the care of our loved ones and also property. So having a plan in place is kindness to your family and promotes peace and unity, especially in times where you have to make difficult decisions. It is an important tool, and we definitely use it at MVLS to promote housing stabilization, which therefore promotes community stabilization. What are you planning for? You're planning to protect yourself, as I stated, your person. If you become sick or when you are dying, that would be an advanced directive or living will. 2, you're going to protect your property and assets if you are unable to make decisions or become immobile for some reason. As we age, that becomes more of a reality and we need assistance, and that would be the financial power of attorney. 3rd, you want to protect your family and your belongings, and you would do that with a will. We know that death facilitates the greatest transference of wealth. Consumer Reports suggest that $68.5 trillion will be transferred in the next 25 years. That is about 2.5 trillion, with 33% of white Americans doing some advanced planning, and estimated 27% of Black Americans doing some type of advanced planning. But in my experience, I would say that those numbers are much less, and in fact, contribute to other issues we have within destabilization of communities, even the vacant epidemic that we have in Baltimore City. So first, we're going to discuss very quickly the advanced medical directive. There are a lot of myths around why one would not consider doing an advanced medical directive when they are well. Some of those myths are, I have never been sick. I can simply tell someone my treatment or my wishes, or my family knows already my end of life wishes. There are 2 parts to the advanced medical directive. The first one is a legal binding contract, and that is when you choose your healthcare agent. Basically, you are naming the person who will be making decisions for you in the event that you are ill or incapacitated or rendered incompetent. It becomes effective immediately, but in most cases, it does not have to be used until those events occur. So this is someone that will assist you or advocate for you when you are unable to make medical decisions for yourself. The second part is your living will. Now, this is optional and it is not a legal binding contract, but it generally outlines your medical preferences. It names how you want treatments, how many interventions you want, and whether you want truly extenuating interventions. Do you want to be put on life support or intubated with a ventilator? Do you want a feeding tube? Would you like narcotics? For how long and how extensive? And this will also help the doctors, guiding the doctors in how they will treat you when you are unable to communicate due to illness and end of life situations. How do you choose? Well, we want to sit down and have really honest conversations with our families, friends, or the people that we are choosing to represent us about our value systems and what matters to us. I always tell people to consider that you are able to make choices now. So if you don't self-determine and take advantage of making choices for yourself now, choices will be made regardless. So think about your beliefs and your value system. Ask people to consider 3 questions. What are your values? What is a good quality of life? And what condition in life is worse than death? When you are able to sit with those questions and answer those questions for yourself and communicate them, you are really ready to answer the questions or fill out the advanced medical directive. There's another form required in the state of Maryland, and it is called the MOST, Medical Orders for Life-Sustaining Treatments. Most people know it as a DNR. These are your resuscitation orders. Do you or do you not want to be resuscitated in those life-threatening situations? They require a doctor's signature, and in the state of Maryland, if you don't have one, whether you have an advanced medical directive or not, and you have named the treatments that you want to receive, if paramedics respond or you are in the hospital, they will resuscitate you for as long as they find that it is in your interest and humane. So to review, who will you name to make your medical decisions? This person should be somebody that is trustworthy. I will repeat that a few times. Not just someone you trust, but someone that is trustworthy, that understands your value system, and is going to respect your wishes. For the living will, what level of care do you want? All, some, or no medical interventions? Do you want to donate your organs or your body to science? The disposition of your body, and you can also name final arrangement preferences. And for a lot of people, because of faith, those things are really important. Do you want blood transfusions? Do you want to be cremated in the event of death, or do you want to be memorialized and buried? How to execute? Well, an advanced directive is one of few forms that can be written, oral, or electronic. Once it is signed, you should make copies and give to your primary care physician, one for your healthcare representative, and if you frequent the hospital, especially because most hospitals function on electronic medical records, it is in your best interest to deliver one to a hospital. And that way, if they have to share it with another system, it can be easily shared. You can acquire these forms generally at your healthcare provider's office, but you also can contact the Maryland Attorney General's office, and that number is 410-576-7000. They will mail one out to you. You can also find it on their website under healthcare policies. Now on to the financial power of attorney. This document appoints an agent to make decisions about what happens to your property, assets, and insurance while you are still living. This is pertinent really to our aging population, those who may have already pre-existing conditions, caregivers, etc. Your agent can arrange the payments of everyday expenses, your mortgage, your rent, doctors, bills, benefits, your insurance policies, make trips to the banks for you, and easily use your payment systems when running errands. A financial power of attorney is a simple way to arrange for someone to manage your finances if it becomes challenging to handle your own affairs. If you don't appoint someone and you become ill, incapacitated, or rendered incompetent, it could end up in the court system, and the courts will appoint a guardian to you. And that's why, again, it is important to begin to make choices when you have the function and faculties to do so. It lasts until death. It can be revoked if you decide to change it, but you would not be able to change it easily if you are rendered incompetent or too ill or incapacitated. So you have to really keep in mind, again, you want to choose someone who is not only a person that you trust, but someone who is truly trustworthy, understands your financial condition, and will respect your values and not exploit you. This one document I do speak of with great sensitivity because it definitely opens people up to exploitation and financial abuse. There are two types. You have the financial power of attorney general and the limited financial power of attorney. The first one gives the agent the power and authority to act on all principal matters in business and personal, and it is effective immediately. The limited power of attorney grants only the powers defined in the document. Things to consider. Who should you name as your financial power of attorney? Again, someone who is trustworthy and is going to respect your value system. Secondly, should you have one agent or joint agents? We discourage having joint agents on both the advanced medical directive and the financial power of attorney. You want to pick one joint agent and also backup agents, co-agents. Backup agents. The risk. Though the power of attorney has an obligation to act in your best interest, sometimes, often, they do not, and they can withdraw money or exploit you for their own personal benefit. Understanding that it becomes effective immediately. If this is a person that is not trustworthy, once it is signed, they can basically take every asset, financial asset that you own, as they will have access to everything. So how to limit the risk? A financial power of attorney, like I said, can have immediate access to all of your financial accounts. So to limit exploitation, sometimes you want to just have the limited power of attorney. You also want to be careful who you choose. You want them to be trustworthy. You want to really sit down and speak honestly and openly with your family about your financial values and condition. And we also have what you call springing language, and that is limiting language, where you can name the amount of gifts, the frequency that you want them to be able to go to the financial institution that you bank with. You can limit the amount of money to be withdrawn, and you can state that they are unable to change beneficiaries on your accounts. In order to create a power of attorney, and I believe I skipped a slide with the advanced medical directive, but you must be 18 years of age, intend to give power to the person designated in the document. And again, you must be mentally competent. In order to create the power of attorney, you must be 18 years old, and it must be in writing. I already said that, signed, notarized, signed by 2 or more adult witnesses. You must all sign in the presence of each other. So your designated power of attorney, your 2 witnesses, and yourself. You will all sign together, and at least one benefit must not have an interest in your financial benefits. So for also to backtrack, the advanced medical directive, you must be 18 years of age, that your personal representative must be 18. You must also have 2 witnesses to sign. That is basically all that is required. You would also all sign in the presence of each other. Now, the last will and testament. This is both documents prior to the advanced medical directive and the financial power of attorney end at death. The last will and testament becomes effective after death. And most people are familiar with a will, and sometimes only the will. It names someone to handle your estate, and we refer to that person as your personal representative or the executor of your will. It can name the guardians of any minor children, but FYI, in the state of Maryland, if you do not file for sole custody or you are not granted sole, legal, and complete custody, the state automatically assumes joint custody. So in the event of your death, if you're the custodial parent, the non-custodial parent, they would defer to the non-custodial parent for guardianship of minor children, unless you have sole legal custody and you can name the next guardian. But with that being said, if they had to defer to the non-custodial parent, you can also name a backup. It also says to where and whom you want your assets to go and how you want them distributed. It can also authorize payment of funeral expenses. And often that is the only thing that happens with a will easily. A will names all of your things, but it actually doesn't move it. Things to consider. Who will be your personal representative? And again, that is the person who oversees the distribution of your assets. If you have children, who will you name as guardian, identifying a backup guardian, and how you want your assets distributed. How to execute. In order to create a will, you must be 18 years of age, have the mental capacity to make a valid will, know and understand the nature and extent of your property, the assets that you are naming, and the disposition that the will is making. How are these assets and matters going to be distributed? The will must be in writing and signed by 2 or more witnesses who sign the will in the presence of each other. And in the state of Maryland, only the original will is accepted. So sometimes, oftentimes, a lot of time has passed since you have created a will, 10, 15, 20 years. It may be hard to find or keep the original in a condition that it could be verified. So what you want to do is file your will with the Register of Wills, and it costs $5. And then they have it on file for your lifetime and after that. So what happens to your property if you don't have a will and you haven't designated beneficiaries? And this is what we call probate. Your heir or personal representative from your family will have to go to the Register of Wills and open an estate. And then who is the beneficiary is determined by intestate succession. And that means they will go down the line of who is the next of kin. First would be your spouse, then your children, then your parents, siblings, and then any other surviving heirs. And that can get tricky as it can split many times over. So one person would have to go and petition the court to open an estate. If you have minor children, they will be placed with someone, a guardian who steps up, or they could just be placed by the court. And this, of course, would increase family conflict and generally lends to family disunity and housing destabilization. So that leads to other options to avoid probate and help for your heirs to inherit more quickly, your assets more quickly and easily. You want to make beneficiary designations. That is the first thing, actually, you can do, the fastest and generally free. You would complete these things by making beneficiary designations with your bank accounts, checking, savings, CDs, money markets, investment accounts, stocks, bonds, IRAs, Roths, your retirement accounts, your insurance policies, most importantly, your retirement funds. Any financial accounts that you have, you can add a beneficiary or make them payable on death. So you want to contact your banks and any financial institution holding accounts. This is generally one form simply that you would fill out for each institution. You also have what you call transfer on death. You can transfer your automobiles, which though they are a depreciating asset, they can still hold a great amount of value. And after death, it is not an easy thing to carry out to get a car titled and a new registration with the MVA. So for each automobile, you can go to the MVA now, and it doesn't have to be paid off. And you can fill out for a transfer on death to title your car to a beneficiary. It costs $20 and just a little time at the MVA. And then most importantly, we cover life estate deeds. And why I say it is quite important, specifically in Baltimore City, this is how a lot of wealth is extracted from our communities or lost. And how we got into actually advanced planning at MVLS was because of the foreclosure crisis that was occurring between 2007 and 2010. We found that a lot of our homeowners, by all intents and purposes, were generational, multi-generational, and legacy homeowners, meaning they lived in the home, they paid the bills, they took care of the property as best they could, but they weren't legally on the deed, which excluded them from homeowner tax credits, water bill credits, tax credits, rehab programs, etc. And the homes would often fall into disrepair. The taxes for the home would exceed their income limits, and it would build and often would end up in what we still have, which is the predatory tax sale. So a life estate deed is another way to move your assets, often your largest asset, your home, to your beneficiaries, your heirs seamlessly. You can retitle your home so that you can keep it for as long as you live, and then it will immediately pass to another person. And the only thing they will need to consider with the home now being transferred to them, title and deed, is to record a new deed for themselves and a lien certificate. Also, in the state of Maryland, you would need to, if you had to open an estate and you need to, and there is property that will be in an estate for your heirs to redeem, they would have to pay all estate administration fees, all back tax bills, all back water bills, any municipal bills, and so they could have a clean lien. A clean lien is required to transfer property unless you have a life estate deed. So those are some of the other planning options and some of the most responsible, and helps to avoid probate. The goal is to pull all of your assets away from probate, making it easier for your heirs and beneficiaries to inherit your assets. So a life estate deed, there are two types. There is what we call a life estate deed with powers and a life estate deed without powers. And the life estate deed without powers offers some protection in the event that you qualify for Medicaid. Medicaid is the only federal program which looks to recoup any money that they spend on medical care for you. They have a 5-year look-back period where they examine your assets, and if you end up in, say, a long-term nursing facility and you don't have long-term care insurance, they will make you spend down your assets, and if you have a home, they will start to extract the equity until they possibly have to force a sale of your property. So if you have a life estate deed without powers, you are giving your home some protection But still, they look back 5 years, but with a life estate deed immediately, you start after every year, you start to receive a credit and lower the amount of equity that they would pull from your home. So it grants future ownership of your house or land to someone else. But the caution with a life estate deed without powers, you give up basically the ability to sell your house without approval from the future interest holder. It doesn't eliminate the ability, but you all would have to agree because it is stating that they have a vested interest in the home. A life estate deed with powers, if you change your mind, you can sell your home or do whatever you would like to do with it. So the benefits, though, is it helps to, again, pull your property and assets away from estate administration or what we know as probate. It allows your heirs, once the homeowner is on the deed, to qualify for property tax credits, water credits through some of the Baltimore City programs, and home repair programs. The cost and the filing fees of a life estate deed is $115. In comparison to estate administration, when you have your assets in probate, you have to pay a 3 to 8% death tax, and you have estate administration between $300 and $500 or more. Remember, you have to have a clean lien certificate, so you would have to pay all back tax bills or water bills, municipal bills on the property. You would have to publish the estate so that if there are any heirs, they would come forward. And then again, when it is all said and done, you would have to record a new deed and get a new lien certificate. So that is the end of my presentation. If you have any further questions of MVLS, again, we deal with family law, which is divorce and custody, adoption, guardianship, and adult protection and conservatorship. We do name changes and birth certificate corrections. Housing, which are landlord-tenant disputes, they are few. We don't deal with evictions because that can be a very fast process. Foreclosures and tax sale. We do deed changes with the My Home, My Deed Legacy program, which overlaps a lot with the estate administration and planning program. We help people to redeem their ground rents. We deal with consumer issues, bankruptcy, Chapter 7, bankruptcy bypass, collections and contract disputes, credit disputes, garnishments, and other areas with like our workforce development program, which deals with expungements, shielding, and vacatures, the LITC, tax controversies clinics, where you deal with income tax disputes, fraud, audits, and of course, my program, the estate planning and administration. And that is it there. I have time for questions.
For a parent given sole physical and legal custody of a child after divorce with the other parent, if that custodial parent dies, does custody of the go to the guardian of their choice, or does the child go to the non-custodial parent, or does a judge decide?
It would be as named in your will. That's why it is important to name guardians or backup guardians. But that is also something that could possibly be contested by the non-custodial parent. But you do have the ability to name the guardians and backup guardians as a legal measure.
Okay.
Mhm.
The next question is regarding a name change after a divorce. Do I have to contact Social Security to change all documents? If I don't, does this pose a problem at the time of death?
That is a great possibility. I don't have the answer exactly to that question, but I would, in fact, if that was not your maiden name, and if you are divorcing and you don't want to confuse or lead to other heirs trying to acquire your property, I would probably complete all legal name changes, because you definitely want to do it on documents like your license and your passport. So possibly making all things the same. So
Okay.
in the case that you have to get new documents, you don't have all of these different documents.
Okay.
I hope I answered, or somewhat
Yeah.
answered.
This next attendee asked 3 questions. I'm going to just read the first one since we have 2 others after that, and
Okay.
encourage the attendee to email you with the following 2.
Yes.
The first question is, who does the estate attorney represent after the death of the person who created the will? For example, if they only communicate with the personal representative, or will he or she communicate with the beneficiaries as well?
Yes. They do represent you. They do represent the estate, but they will communicate. That is part of their responsibility, to communicate with the heirs so named in the will.
So follow-up question to that. Do beneficiaries of a will in Maryland have rights to know about the estate?
Beneficiaries, they have the rights to know how they are named in the estate.
Okay. So they have the right to see the section of the will that names them.
That names them.
Okay.
Yes.
All right. Next question is, for an absentee parent that has never been involved 10 years, would a dependent go to the absentee parent if no court case ever convened?
The courts would defer to the biological or non-custodial parent or guardian. Yes.
Okay.
So joint custody is assumed in the state of Maryland until you file or are granted otherwise. So yes.
Okay. Next question is a life estate deed something that a lawyer would prepare first and then file for the $115 filing fee, or is it something that you prepare and file yourself?
So also, and I want to go back to speak to the question about the wills and the beneficiaries. So in most cases, if you have you do have a will and you've named the beneficiaries, again, you are still dealing with the estate administration and probate. A will names your heirs possibly, and your property. It might not name all of your heirs. So if you have not designated beneficiaries, everything is going to estate administration. There could be a will that names all of your property, but it might not it doesn't necessarily move it, and it might not be in respect of just those heirs named. I'm sorry. And then the life estate deed. Yes, you do want a lawyer to prepare a life estate deed as well as the will. The advanced medical directive and a financial power of attorney. You can get the financial power of attorney at any financial institution. You can walk in your bank and get a copy. The advanced medical directive you can get from your physicians or hospital. The will in the state of Maryland has a lot of legalese or legal language that should be in the will. You can't just, I think, print it off of like wills.com or whatever legal site, because this language is required to make it valid. So if you don't have that language, it could void it or make it moot. So you do want a lawyer to prepare a will, and you do want a lawyer to prepare and review your life estate deed. And then that $115 is actually 2 payments. You would just be recording a new deed and getting a new lien certificate. And we have had people because they have the life estate deed, it just moves the property seamlessly, and they have yet to go and record a new deed. But we encourage your heirs or descendants to do so. But it is not immediately necessary until they actually acquire the property and begin to do their own advance plan.
Okay, and final question. And again, I would encourage for anyone that asked an unanswered question to either contact you through the, I know that your contact information is on the MVLS law
Website.
or
I'm
website.
sorry. I need to add it to a slide.
But also our next presenter is an attorney, so these questions could carry over to the next presentation as well.
Yes.
So
Okay.
the last question is regarding heir property. How do you go about changing to specific names instead of the heirs of? For example, a house fire destroyed the house. What do you do about the land property?
So the current owner of the land can still do a life estate deed. It transfers land and the buildings built on it. So if you own the land, you can still do a life estate deed to transfer the land seamlessly.
Okay. And how do you go about changing to specific names instead of the heirs of so-and-so?
Well, I mean, on the life estate deed, you are naming specific heirs.
Okay.
And we encourage you again to name as few heirs as possible. Possibly one if you had to make a choice. Because again, I mean, you will deal with then multiple heirs. And in the event of, if you have multiple heirs in the event of their death, is going to continue to split. Also, to speak to life estate deeds, we have in a lot of cases, property owners, especially married couples, they're both on the deed and they have equal shares in the home, but they don't have clause on the deed that says in the event of death that their spouse's percentage of the home passes in its entirety. So it's also important to make sure that those clauses and statements exist on your deed, or to also do a life estate deed. So in the event of a spouse's death, that property, that 50% could be passed to the living spouse, or if the spouse is not on the deed and they would be the first named in intestate succession, still they would have to go through all of the things you need to go through with estate administration and probate to redeem the property. So you still want to have a life estate deed to protect your spouse.
Okay, great. That's all the time we have for questions.
Okay.
Thank you again, Aisha.
Thank you.
Thank you, everyone.